Friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing latest adjudication order for the violation of Section 118 by the Delhi ROC. In this case, company name is the India Bulls Housing Finance Limited, and this violation of a secretarial standard of Section 118, subsection 10, and in this case, company master data. As per the master data, company having registered office at Delhi, and as per the master data, there is the paid up capital in crores 93.71 crore, and turnover for the financial year 2021-22, that is the 7,765.39 crore, other income 12.31 crore. Holding company, there is no status of holding company. No subsidiary company. There is yes, this is a subsidiary company, or whether not Section 8 company, and not registered under any special act. That's why, as per this criteria, companies are not a small company. Let's see the facts of the case. An inspection of the books of account and other records of the caption company was conducted under Section 206 subsection 5 of the Companies Act 2013. During inspection, it was reportedly observed by the inspecting officer that the company has not complied the provision of Section 118 subsection 10 read with the secretarial standard. Company had filed an application for adjudication while e-form GNL 1 for violation of Section 118 of the Companies Act read with the secretarial standard 1 issued by the ICSI. The RD Northern Region, by letter dated 11th January 2022, has directed this office to take action under Section 118 of the Companies Act against the above application of the company. A so-called notice was issued on 31st January 2023 to company and its applicant, and in response to the said so-called notice, subject company submitted its reply. An authorized representative appear for the hearing on behalf of the company and all other applicant, and stated as under that the company and concerned officer have willfully moved the application for adjudication of penalty under Section 118 read with the para 7.3.1 of the secretarial standard 1. It is the case of a company that the incoming independent director had duly declared their interest in the other entities in the MVP1 before the board. However, inadvertently, those declarations could not be taken note of in the minutes book. Further, authorized representative has additionally submitted that one of the applicant was appointed on the board on 21st October 2016, so no penalty be imposed on him for the default in respect of the minutes for the financial year 2014-15. The relevant provision of Section 118 as on the date of default are as under that as per Section 118, minutes of the proceeding of general meeting, meeting of the board of directors and other meeting and resolution passed by the postal ballot. Every company shall observe, as per subsection 10 says that every company shall observe secretarial standard with respect to the general and board meeting as specified by the ICSI under Section 3 of the Companies Secretary Act 1980 and approved as such by the central government. If any default is made in compliance with the provision of this section in respect of any meeting, the company shall be liable to a penalty of the 25,000 rupees, and every officer of the company who is in default shall be liable to a penalty of 5,000 rupees. The relevant provision of the secretarial standard 1 issued by the ICSI as on a date of default are as under: recording of the minutes. Minutes shall contain a fair and correct summary of the proceeding of the meeting. Adjudication of the penalty. The subject company and its officer who have made the default in respect of not taking note of the MVP1 of incoming independent director, and subject company does not get covered under the purview of the small company as defined under Section 2 clause 85 of the Companies Act 2013. Hence, the benefit of section lesser penalty under Section 446B would not be applicable on the company and not in exercise of the power. Now, this power is exercised under sign by this notification 24th March 2015, and having considered the reply submitted by the subject company in response to the notice issued and hearing of the matter, hereby impose a penalty on the company and official default under section 118 subsection 11 of the Act for the violation of clause 7.3.1 of the Secretariat Standard 1. And here on the company there is a default over 2 years, 2014 and 15 and 16 17. That's why 25,000 penalty multiplied by 2, that is 50,000 on the company. And here there are 1 2 3 4 5 6 7 director officer in default on 10,000 each, and on the last one for the 1 year default, that is 5,000 each, 5,000. And the here period of default for the board meeting held on the 19th January 2015 financial year taken as 2014-15, and for the board meeting held on the 20th January 2017 for financial year is taken as 2016-17, and hence order is passed. Name of the party as mentioned in the table hereby directed to pay the penalty amount as per the column given. In case of the party other than the company, such amount is required to be paid out of their own funds. The said amount of the penalty through online by using the MCA website in favor of Pay and Accounts Office, Ministry of Corporate Affairs, New Delhi, payable at Delhi within 90 days of receipt of this order, and intimate this office within the proof of penalty paid. Appeal, if any, preferred within the 60 days from the date of the receipt of this order in Form ADJ, setting forth the grounds of the appeal and shall accompanied by certified copy of the order. In case of the violation, non-complying of this order, section 454, section 8 of the Companies Act is attacked, and in the act of the event of non-compliance of this order. Thank you so much for watching this appellant order, adjudication order.